Welcome back. This is lecture 6.2, talking about the plain view doctrine. The plain view doctrine is defined as the legal principle that objects in plain view of an officer, a law enforcement agent, who has the right to be there in that position and have that view, may seize that evidence without a warrant. And if needed, introduce it into the case as evidence. And the plain view doctrine was first put forward by our Supreme Court in Coolidge v. New Hampshire, which was in 1971. And the court ruled that law enforcement officers may make a warrantless seizure of an item if the following four criteria are met. So the item is positioned so as to be detected easily by an officer's sight or some other sense. The officer is legally in a position to notice that the item is in question, and the discovery of the item is inadvertent. That is, the officer had not intended to find the item, and the officer immediately recognizes the legal nature of the item. So no interrogation has to happen or further investigation, or none of that can happen. It's really not allowed under the plain view doctrine. And advances in technology that allow law enforcement agents to see beyond normal human capabilities have raised some new issues in regards to plain view principles. And the question for the courts has been whether a warrantless search of a dwelling through its walls by means of the thermal imaging violates Fourth Amendment protections of privacy. And according to the Supreme Court, an item is not in plain view if law enforcement agents need the aid of that technology to see it. Thus, any information that's received from thermal imager is not by itself some sort of justification for a warrantless search. So electronic surveillance is defined as the use of electronic equipment by law enforcement agents to record conversations or observe conduct that is meant to be private. Let's talk about some basic rules. So given the invasiveness of electronic surveillance, the Supreme Court has generally held that the practice is prohibited by the Fourth Amendment. And in general, law enforcement officers can use electronic surveillance only if consent has been given by one of the parties to be monitored, or in the absence of such consent with a warrant. And for the warrant to be valid, it must have the following information. Detail, there has to be particularity that the conversations that are about the conversations that are being overheard. It must name the suspects and the places that will be under surveillance, and it has to show, again, here we are, probable cause to believe that a specific crime has been or will be reported. And in any case, the surveillance cannot last more than 30 days without judicial extension. So there are force multipliers, and certain pervasive forms of electronic surveillance are allowed under the theory that people who are in public areas have no reasonable expectation for privacy. And this theory, greatly upheld by American courts, allows for the use of a number of technological force multipliers or devices that allow law enforcement agencies to expand their capabilities without a significant increase in personnel. So let's talk about, I want to just review really quick before we go on to stop and frisk about cell phones and the Fourth Amendment and searches of cell phones. And in California v. Riley in 2014, the Supreme Court ruled unanimously that police officers needed a warrant to search the contents of the cell phones that belonged to the suspects that they just arrested. And because of the vast amounts of personal information on cell phones, however, the court decided that these items deserve greater protection than items such as wallets and cigarette packs. So furthermore, Once a cell phone has been secured by police, the arrestee will not be able to delete incriminating data, and the data on the phone can endanger no one. That's the two primary justifications for warrantless searches incident to arrest. So what is stop and frisk, and what is the importance of this case, Terry v. Ohio? Terry v. Ohio is one that I'm definitely going to want you guys to be aware of. It's an important Supreme Court case in law enforcement. So the precedent for the ever elusive definition of reasonable suspicion in these stop and frisk situations was established by Terry. And there's this test that occurs as law enforcement officers, and it's basically considered the totality of circumstances test. And in this Terry case, Terry v. Ohio, the Supreme Court did say that an officer must have specific and articulable, so being able to articulate what those facts are, to support the reason that they made the stop, but added that the facts may be taken together with rational inferences. So in the years since that Terry case was decided, the court has settled on a totality of circumstances test to determine whether a stop is based on reasonable suspicion. So the justices also made clear that the need to prevent terrorist attacks is part of the totality of circumstances. And therefore, law enforcement agents have considerable leeway to make stops near U.S. borders. Okay. So with a stop takes place when a law enforcement officer has reasonable suspicion that criminal activity has taken place or is about to take place. In 2004, the court held that police officers could require suspects to identify themselves during a stop, and that is otherwise valid under the Terry ruling. Now, when we talk about a frisk is a pat down or minimal search by police. And it's not a fishing expedition. They can't conduct, what is coined as a fishing expedition simply to try to find an item besides a large weapon. A frisk does not necessarily follow a stop, and in fact may occur only when the officer is justified in making or thinking that the safety of the officers or other citizens is endangered. In 2009, the court extended the stop and frisk authority by ruling that a police officer could order a passenger in a car that had been pulled over for a traffic violation to submit to a pat down. And to do so, the officer must have a reasonable suspicion that the suspect may be armed and dangerous. So that is an important piece when we're talking about Terry versus Ohio. So what are some rules of making an arrest? There are 4 elements that we are going to cover when we're talking about rules for making arrests. An arrest is the act of apprehending a suspect for the purpose of detaining him or her on a criminal charge. So we have to have these elements of the arrest. So in the eye of the law, a stop is a relatively brief intrusion on a citizen's rights, whereas an arrest involves a deprivation of liberty and calls for a full range of constitutional protections. So consequently, while a stop can be made based on a reasonable suspicion, a law enforcement officer needs probable cause to make an arrest from there. So our elements of arrest: criminal justice professor Rolando V. Del Carmen of Sam Houston State University has identified the following 4 elements that must be present for an arrest to take place. The intent to arrest. As intent is a very subjective term, it is sometimes difficult to determine whether the police officer intended to arrest. The authority to arrest. State laws give police officers the authority to place citizens under custodial arrest or take them into custody. Seizure or detention. Detention is considered to have occurred as soon as the arrested individual submits to the control of the officer. and the understanding of the person that she or he has been arrested. So, through either words such as "you are now under arrest" or actions, the person taken into custody must understand that an arrest has taken place. So you can see this breakdown. This is a great graphic here that goes over some of the scopes of the searches that exist when we talk about the differences between a stop and an arrest. So arrests with warrants is a type of written order, and there is probable cause that's been signed by a judge or a magistrate, and it basically commands that the person named on the warrant be arrested by the police. So there is a perception that an arrest warrant gives law enforcement officers the authority to enter a dwelling without first announcing themselves. But in Wilson v. Arkansas in 1985, the Supreme Court reiterated the common law requirement that police officers must knock and announce their identity and purpose before entering a building. But under certain circumstances and conditions, which would be known as exigent circumstances, this is where situations require extra legal or exceptional actions by the police. Law enforcement officers need not announce themselves. As determined by the courts, these circumstances arise when officers have a reasonable belief of any of the following. So the suspect is armed and poses a strong threat of violence to the officers. The person inside the dwelling or in the process of destroying evidence or escaping because of the presence of police, or a felony is being committed at the time the officers enter. So when we talk about the waiting period, the Supreme Court severely weakened the practical impact of the knock and announce rule with its decision in Hudson v. Michigan, 2006. And in that case, Detroit police did not knock before entering the defendant's home with a warrant. Hudson argued that the drugs found during the subsequent search were inadmissible because the law enforcement agents did not follow proper procedure. In his majority opinion, Justice Antonin Scalia stated that an improper knock and announce is not unreasonable enough to provide defendants with a get-out-of-jail card free by disqualifying evidence uncovered on the basis of a valid search warrant. In other words, the exclusionary rule does not apply. So when we talk about these warrantless searches, arrests without warrants, what if a police officer makes a stop without reasonable suspicion and it leads that stop to a valid arrest? And the Supreme Court addressed this issue in Utah v. Strieff in 2016. And the case arose when a South Salt Lake, Utah police officer stopped Edward Strieff as Strieff was leaving a house under surveillance for narcotics activity. And as often happens after a stop, the officer ran a warrant check and found that Strieff was wanted for a minor traffic violation. The officer arrested him, searching him, and found a baggie containing illegal drugs. And in this situation, as Justice Clarence Thomas noted, the officer was at most negligent. Therefore, the court ruled that the illegal drugs found on Strieff were admissible, creating what could be called a negligence exception to the exclusionary rule. So, disagreeing with the majority opinion, Justice Sonia Sotomayor argued that the Fourth Amendment does not tolerate an officer's unreasonable searches and seizures just because he did not know any better. So a warrantless arrest is defined as an arrest that's made without a warrant for the action. And a law enforcement officer must or may make a warrantless arrest in any of the following circumstances. The offense is committed in the presence of the officer has probable cause to believe the suspect has committed a particular crime, and the time lost in obtaining a warrant would allow the suspect to escape or destroy evidence. And as a general rule, officers may make warrantless arrests for for a crime they did not see if they have probable cause to believe that a felony had been committed. And for misdemeanors, the crime must have been committed in the presence of the officer. We will stop here and come back to the next lecture shortly.